securities laws are very complicated, but they're basically consumer protection laws. They are designed to protect unsophisticated investors from losing their life savings on fraudulent, businesses. An equity investor is very different. This is not a loan. The investor makes a contribution to the capital of the company, the corporation or LLC, and the holder gets a percentage of the future profits and distributions of cash. Another thing is, too, when you do your cost projections, be sure to be very granular with those. One of the biggest things, and of course, as a lawyer, I see this all the time, one of the biggest mistakes that people make when they do their cost projections, they forget to include legal and accounting fees, which can be very substantial.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Cliff Enico. Cliff Enico is a leading expert on legal and tax issues for entrepreneurs, known for hosting Money Hut on PBS and writing the syndicated column Succeeding in Your Business. He is also the author of multiple books on entrepreneurship, crowdfunding, small business law, as well as legal treatises for Thomson West. With a 45-year legal career, he has represented over 15,000 small businesses and previously worked at a top New York City law firm before establishing his own practice in Fairfield, Connecticut. He is a Dartmouth and Vanderbilt law graduate and an active speaker, YouTube host, and contributor to Entrepreneur and other business publications. The webinar presentation that you're about to watch will be approximately 1 hour, and once that is complete, Cliff will be taking questions from the audience, time permitting. So if you have any questions that come up, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen and sending them on over there. Now, without further ado, here is Cliff to discuss an introduction to securities law for the general practitioner.
Thanks, Dina, and thanks for the wonderful introduction there. It's hard to believe I've done all that stuff, but I've been around a pretty long time here. First of all, let me sort of begin with a little disclaimer. Being a lawyer, I always have to tell you what I'm not going to do before I tell you what I'm actually going to do. I'm really not a securities law specialist. I am something of a generalist. My practice focuses on representing small businesses and entrepreneurial startups. I've worked with thousands of these people in the course of a 45-year career. Securities law is one of 36 different areas of the law that you have to know something about when you represent a small business or a tech startup. And this program is really going to be dedicated to the non-securities law specialist. If you are a specialist in securities law, if you're with one of the big Wall Street firms and you do this sort of thing, this is going to be very, very basic for you. The goal of this program is to let attorneys who are not securities law specialists know when they have to start thinking about securities law and whether this is something that they can do themselves for their client or whether they have to bring in a securities law specialist. So with that as sort of a little bit of disclaimer, let's get started. First of all, I just want to give an overview of federal and state securities regulation in the U.S. When I was in law school, I took an entire semester course on this. I've distilled this into like 4 slides. So again, it's going to be very, very basic. We're looking at this from 5,000 feet up, folks. But when do the securities laws apply? Okay. There are 2 kinds of entity that I work with. I work with small businesses and I work with startups. A small business is usually a retail or service business, a business that's not scalable. In order to grow the business, you have to put in more time, spend more money, that kind of thing. They usually have a very local marketplace. They're not national or global in scope. The workers and the owners are usually the same people. When you go to your local deli, the guy that's slicing your bologna is also a 20% shareholder in the corporation that owns the business. And most importantly, they're not designed to grow big, but they are designed to grow long. I'm working with some businesses now that have been in business for over 100 years, and they're in the fourth generation of ownership. With a small business, the goal is to create value for future generations. A tech startup is very different. A tech startup is usually in manufacturing, technology, media, a scalable business where you don't have to keep incurring costs to grow the business. The growth curve is more of a parabola than a straight line. The market is global or national or global in scope. The owners and the workers are not this often the same people. You have labor and capital, and they're very different. A tech startup is designed to have outside investors, with people who are passive investors. I own some shares of Microsoft. That does not mean that Bill Gates can call me on the weekend and say, "Hey, Cliff, we're a little late with our latest Windows update. Can you come in and do some coding this weekend?" They can't do that to me. I'm just a passive investor. I just expect to see a passive return on my investment, and they are designed to grow big. In fact, most tech startups, their goal is to achieve an exit strategy within, say, 5 to 7 years. And there's only two ways that a startup can exit. It either goes public with an IPO, or it more commonly it gets bought out by a much bigger company and becomes the XYZ division of Microsoft, whatever. So that's the difference between a small business and a startup. Um, Generally speaking, most small businesses and startups go through 5 stages of capital raising. There's the money that the founders put in, and this includes things like credit cards, home equity lines of credit, HELOCs, any money that goes to them first and that they put into the company as a capital contribution is considered founders' money. Once that money has been exhausted, the next thing they usually do is they go to a friends and family round where they start raising money from Uncle Cliff, who will loan them $50,000 in a convertible note or something like that. For most small businesses, that's as far as it goes. If you're a tech startup, however, there are 3 other levels of capital raising. There's angel and seed capital money. This is money that is put in by wealthy individuals called angels. They're usually people who either live locally where the business is located or are players in the industry in which the company operates. And those are not usually big loans. They're usually $250,000, $500,000, and it either is debt or they'll buy some stock. Then you go to the venture capital round, the Series A, B, and C, and those are mostly preferred stock offerings. Then last but not least, if the company is truly successful, you do your initial public offering or a sale to another company. You exit, you pull the trigger and you effect your exit strategy, which then you either become part of a much bigger company or you go public and you're on the NASDAQ and the Fortune 500. Technically, all involve offerings of securities, even the founder's money, but the securities laws generally come into play after the friends and family round. Usually in a friends and family round, unless there are lots and lots of people involved, like a crowdfunding, you will not usually be too involved with the securities laws. It's when the company goes beyond that. Basically, whenever a company is raising money from people that they don't know personally, or that the founders do not know personally, you have to be concerned about the securities laws. That's Cliff Eneco's rule. Whenever your client is starting to offer money to people that are not already friends and family, it's time to start thinking about the securities law. Keep in mind, when we talk about the securities law, I mean, securities laws are very complicated, but they're basically consumer protection laws. They are designed to protect unsophisticated investors from losing their life savings on fraudulent, businesses. The people years ago that used to offer, interest stock in the Brooklyn Bridge to unsuspecting people from out of town that didn't know that they didn't know. And how did they do that? By the way, believe it or not, they used to do it legally. What they did was they basically offered these people quitclaim deeds, saying whatever title and interest I have to the Brooklyn Bridge, I'm selling to you. Very clever. They're not saying that they do have an interest in the bridge, but most unsuspecting investors did not know that. Little piece of history there. Okay, so what is a security? Let's start off right off the bat with the basic question. Securities are basically stocks, bonds, and anything else that would be an investment contract. There was a famous 1940s Supreme Court case called the Howey case. It was a case involving a Florida citrus grower who got, during the Depression, had trouble selling oranges to people. So what they decided to do was to sell pieces of next year's crop. And the profits from next year's crop to various people. Wasn't a traditional stock or bond in the company or anything like that. Went to the Supreme Court, and the Supreme Court says no. And in any kind of investment contract in which there's an investment of money in a common enterprise with an expectation of profit derived from the efforts of others is a security for purposes of the federal securities laws, and the states have followed suit. Types of security, just about any investment in a small business or a tech startup can be either debt or equity. In a debt investment, the holder gets a fixed return on investment. It's a loan. A debt is a loan. Basically, the investor is lending money to the company. They get an interest back on that, which is called a coupon, but they don't have any say in the management or operation of the business. They are a creditor. The trade-off here is that the investor who buys a debt security, a note, convertible note, a bond, or any kind of corporate IOU, doesn't have the right to tell management what to do. They're an outside creditor. They just sit back and collect money each month when there's a principal and interest payment. However, this is an obligation of the company. The debt must be paid back with interest. The company can't just say, well, we don't have enough money. We can't this month. We can't really pay this. They must. If they do not, then the loan goes into default and the creditors can seize the assets of the business if it's a secured loan, which most of these things are. So that's what the debt holder is getting is he's not getting that big a return. You don't get rich loaning money to companies, but you get a guaranteed return and you get a safe return. If the company goes belly up, holders of debt get paid back before anyone else does. Okay, that's the trade-off that a debt investor is making. An equity investor is very different. This is not a loan. The investor makes a contribution to the capital of the company, the corporation or LLC, and the holder gets a percentage of the future profits and distributions of cash in the company. For a corporation, this is called a dividend. They also get a say in management and operations. The downside to equity investments is these are not obligations. The company only has to pay them back when they have sufficient capital to do so, and it's at the discretion of the board of directors or the people that are running the company. So if the company does not have enough money to pay a dividend for a certain month or quarter, they do not have to. Legally, they can wait until they have sufficient capital to pay back investors with. But the upside again is the trade-off here is that equity holders are stockholders. They own a piece of the action. They have the right to participate in the management and the operation of the business. They can tell management what to do, and believe me, at the annual shareholders meeting, they usually do. They're very vocal about this. The downside is that they don't have to be paid back on any particular time frame, and they're at the bottom of the pecking order should the company go bankrupt. If the company goes belly up, the debt holders get paid first, and whatever is left over, if anything, goes to the holders of equity. So those are the trade-offs that debt holders and equity holders are making. For C corporations, debt, common stock, preferred stock, safes. This is a relatively new thing. Simple agreements for future equity. It's basically a contract that gives an investor, that takes an investment from an investor in exchange for an equity in the company, but it doesn't say exactly how much equity they're going to receive. It's usually conditioned upon a future event, usually an offering of preferred stock, a Series A offering. It's kind of a hybrid between debt and equity, although if it's done right, it's usually taxed as equity. It's not treated as a debt of the company. For S corporations, these are corporations that have elected to be taxed as if they were partnership. They cannot have preferred stock, so it's usually just debt and common stock is all that they can do. For limited liability companies, LLC, they don't issue shares of stock, but you can, for tech startups, do something called units of membership interest. which function very much like shares of stock, which can be taxed either as capital interests or profits interests. The tax laws, when it comes to LLCs, whenever you're issuing securities in an LLC, you have to watch the tax laws because there are some rules that apply just to LLCs, and you have to make sure that you're in compliance with those. Okay. There are both federal and state securities laws. Securities regulation, there is concurrent jurisdiction. Both the federal government and the state government, under the Constitution, can regulate offerings of securities. The main federal stat law is the Securities Act of 1933. This is the law that governs new issues of securities, and the key provision is Section 5. Section 5 of the 1933 Act requires all stock offerings to be done as IPOs, as initial public offerings, unless one or more exemptions are available. I got a call from a company recently that had formed several years ago. It was a Delaware corporation, a Delaware C corporation, and these people had been issuing stock to investors for $1,000 each. Where they were offering basically 100 shares of their company for $1,000 each to anybody and everybody. They had it posted up on their website. Hey, become an investor in our company. For each investment of $1,000, you get 100 shares of our company. And they had been doing this for several years. I was the one who had to break the news to them that they cannot do that. That is an unregistered public offering. Is what they were doing. They were doing a public offering, but they hadn't registered the public offering with the SEC the way Section 5 requires you to do. That was not a very pleasant conversation. I did offer to help them bail them out of that situation, but they couldn't afford my fee. I never heard from them back again. So keep in mind that you must, under the Federal Securities Act of 1933, you must do an IPO unless you fall within one of several exemptions. And there are several exemptions from the public offering requirement of Section 5. Section 3 exempts certain securities. Mostly you will, as a non-securities specialist, you will not get into this all that much, but things like municipal bonds, for example, are exempt. Certain stock that banks issue, there are no, Section 3 doesn't really exempt any type of security that would affect a small business or a tech startup. Section 4 is the more important set of exemptions. This exempts certain transactions in securities from the public offering requirement of Section 5. And the three that you will see most often in your practice are sections 4A2, 5, and 6. 4A2 provides an exemption for offerings to accredited investors in any amount, and we'll define what that term is in a minute. But if you're offering only to people called accredited investors, you don't really have to worry about the public offering requirement. You have an exemption from that requirement. 4A5 covers small offerings, offerings to accredited investors of up to 5 million. And then there's section 4A6, which relates to crowdfunded offerings under the SEC's regulation crowdfunding. We'll talk about those in a minute. Section 12 of the 1933 Act has penalties for noncompliance. If you do an offering of securities that should have been registered as a public offering, but did not fall within one of the several exemptions that are in the 33 Act, then there are both civil and criminal penalties. You could go to jail, basically, for not doing that. Section 18 is the last section of the 33 Act that you need to be aware of. This was a section that was adopted in 2006. It basically says that if you are doing an offering of securities under Section 4A2 or 4A6, under one of those two exemptions, you do not have to do anything at the state level. You do not have to worry about complying with state securities regulations. All you have to do is comply with the federal regulation, and basically you're done. There's one little exception to that. If you are doing an offering under Section 4A2, the states can require a notice filing it's SEC Form D. And what you do with that is you file it with something called the NASA Securities Database, which is the NASA is the Organization of State Securities Law Administrators. They maintain a database. If you file your Form D with that, and it's actually very easy. I've done it several times for my client. You log on to the site, you take your Form D, you post it, you create a file for your client, you post your Form D there, and then you check the states in which all of the individuals investors reside. And when you do that, and you pay the fee, there's obviously a fee charged by each state. You have complied with this notice filing requirement. They've actually made this very easy. However, unfortunately, not all of the types of exempt offerings are exempt. If you are doing an offering, for example, under Section 3B of the 33 Act, which exempts offerings and sales up to I think it's $5 million, but not to accredited investors, to anybody all and sundry, that has to be, there are state laws that apply to that, and you have to comply with each state, the laws of each state in which the investors reside. The second major securities law at the federal level is the Securities and Exchange Act of 1934. This is the statute that regulates public companies. Once they do an IPO and they become a public company and they're listed on NASDAQ or the big board, this is the statute that regulates public companies and securities exchanges. And they also, the most important section of the 34 Act is the section that describes securities fraud, which is Section 10B. If your client offers securities and lies in their offering document about what they're doing, they're committing a fraudulent offering, this is the statute that says what happens in a situation like that. So that's just a brief overview. Now, those are the statutes at the federal level. We also have several SEC regulations under the Federal Act that we have to take into account. And the most important of these is Regulation D. Regulation D is a safe harbor. What that means is that if your client is doing offerings under Sections 3B or 4A2 of the 33 Act, and they fall within these Regulation D guidelines, they are safe. They do not have to they are automatically deemed exempt from the public offering requirement of the 33 Act. Let's say, though, that you don't comply with all of the not all of the Regulation D requirements. Well, you still may have an exemption, but it's up to the courts at that point to determine whether or not you do have an exemption. So if you're doing an offering under Regulation D, you really want to shoehorn as much as possible into the letter of these regulations. There are 6 main sections of Regulation D. Section 501 defines accredited investor, that term. Basically, it's very rich and sophisticated people who do not need the protection of the securities laws. So, for example, if you're offering sale stock, and Bill Gates wants to invest in your or Elon Musk, or pick your favorite tech titan, we don't have to really worry about this person being duped by a fraudulent investment. This person is filthy rich. They got tons of sophisticated advice that they get. They do not need the protection against them. Remember, the securities laws are consumer protection laws. They're designed to protect ordinary people from getting suckered into fraudulent investments. These people, accredited investors, are not ordinary people, and they do not need the protection of the securities laws, and the securities laws recognize that. And by the way, if any of those individuals do want to invest in your company, say yes. Okay, that's Cliff's rule right there. Okay, Section 502 that contains a number of different stations. The most important one here is Section 502B. If you are doing an offering of securities to non-accredited investors, ordinary people, okay, which some of the exemptions do allow, then you have to deliver them an offering statement. And if that offering statement is not accurate, your client will be guilty of securities fraud under Section 10B of the 34 Act. And there are very heavy penalties for securities fraud. You basically go to jail for an awful long period of time. Section 502C, some of the exemptions allow you to do general solicitation. You can take out an ad in the Wall Street Journal or post the offering and details on your website. Some exemptions allow for that. Some do not offer that. And Section 502C defines what general solicitation and advertising is. Section 503 is the section that requires the filing of a notice on Form D for certain exempt offerings. Even though your offering is exempt, you usually have to file Form D with the SEC and with that NASA database that I referred you to. By the way, when I refer to NASA, NASA is not the space agency that we are talking about. It's NASAA. There's a second A there. It's the North American Securities Administrators Association. It's the organization of state securities law administrators to try to get those of you who know what the uniform laws people are all about, the people that do the UCC and the other uniform laws. It's the same kind of concept here. This is an organization that tries to get some kind of uniformity and consistency of all the state securities laws in all of the 50 states is what it does. And they're the ones that maintain the database. Section 504 is basically has the rules for offerings under Section 3B, the small offering exemption, and Section 506 it deals with the offerings under Section 4A2. Interestingly enough, there is no section of Regulation D that deals with offerings under Section 4A5, which is very interesting. 4A5 is the one that says that exempts offerings to accredited investors of up to $5 million. There's no Regulation D safe harbor for that. So if you're relying on 4A5 for your offering, you don't really have a lot of guidance as to when you are within the exemption and when you're outside the exemption. Regulation crowdfunding is a separate SEC regulation. It was adopted in 2016. I actually wrote the leading book on this regulation. It's called the Crowdfunding Handbook. You can get it wherever books are sold, on Amazon or everybody else. It'll set you back about $25. It is not a safe harbor. Regulation crowdfunding is how you make offerings under Section 4A6 of the Act. If your client wants to do a crowdfunded offerings of securities, it must comply with regulation crowdfunding. Okay, there are two other exemptions that you need to be aware of. Regulation A is a mini IPO for larger offerings of securities, $5 million and more. And then there's Regulation S under the 33 Act, which provides a safe harbor for offerings made solely to non-U.S. investors. So let's say, for example, your client is offering preferred stock to 10 investors in Europe, in the European Union. These people are not U.S. citizens or U.S. residents. They do not have to register in the United States, but Regulation S provides certain rules to make sure that the offering doesn't blow back in some way to the United States, and you have to be aware of that. Okay, so that's how securities are regulated at the federal level. There are also state securities laws. They are called the blue sky laws and regulations. Every state has one. They may or may not be preempted by federal law. That's that Section 18 of the 33 Act that I referred to. Not all offerings are preempted. There are some offerings, for example, offerings under Rule 504 of Regulation D and under Section 3B of the Act, where you have to look at the securities laws of each state to make sure that exemptions are available. Most states have adopted uniform securities laws. There are two uniform statutes out there that most states have adopted, but not all. There's the Uniform Limited Offering Exemption, or the ULOE, and the Small Corporate Offering Registration, or SCOR. Those are the two. They've been adopted by most states, but a lot of states, including some big ones like New York, have not adopted either of these uniform statutes. Most of these states have de minimis exemptions for transactions involving fewer than X state residents. So, for example, if you're doing an offering of securities and there's 10 investors, but only one of them lives in New York, you probably do not have to worry about New York's state securities law, because it's in most states the de minimis exemption is somewhere between 5 and 10 exemptions, although it can be smaller. I believe Texas, it's 3 investors. But generally speaking, if you've only got 1 or 2 investors in each of the states where the offering is conducted, you may not have to worry about state-to-state securities laws. You still have to comply with the federal rules, but not the state rules. Most do require filing of the SEC Form D with the NASA Electronic Filing Depository, and there's the URL for the depositories you can see here. New York is a parallel universe. New York has its own securities law. It was adopted in the early 1900s. It's been amended a few times, but it follows a wholly different way of securities regulation. So that's an advanced topic for another day. Okay, so let's drill down now. Let's talk about the federal exemptions. Okay, so Section 3B and Rule 504. under Regulation D. And by the way, the footnotes that you see there, if you open the notes section of your PowerPoint, you'll see all of my citations. I do all of my citations in the notes section of the PowerPoint. I don't like to clutter up the PowerPoint text with citations to authority, but they're there. Just open the notes section in your PowerPoint software, and you'll see it, and you'll see them. These are offerings up to $10 million during a 12-month period. You can offer to both accredited and non-accredited investors. This is not an offering that is limited to accredited investors, but there's no general solicitation and advertising. Now, the thing you need to know here is that in 504 offerings, there are additional rules at the state level that you have to comply with. This was one of the exemptions that was not preempted by Section 18 of the 33 Act. Section 482 and Rule 506B allows you to offer an unlimited amount of securities to accredited investors and up to 35 non-accredited investors. There's no general solicitation and advertising, but there's also no state law registration required, except for the notice filing with the NASA database. That's the only thing you have to do there. Similarly, Section 482 and Rule 506C of Regulation D allows you to offer an unlimited amount of securities, accredited investors only. The 30, you cannot offer to up to 35 non-accredited investors. You can use general solicitation and advertising to promote the offering, and no blue sky generation. The difference between 506 and 50B and C is that in 506C, you can use general solicitation and advertising. You can take an ad in the Wall Street Journal, post it on your website, do whatever, but the condition here is that every single investor who comes in has got to be an accredited investor. If you make one mistake, you've blown that exemption. In 506B, you have a bit more discretion. They do allow you to make up to 35 mistakes, basically. You can offer to 35 ordinary people, but they do not allow general solicitation and advertising. All solicitations must be done one-on-one with the individual investors. Section 4A5 allows up to $5 million, accredited investors only, no general solicitation and advertising, no Regulation D safe harbor. As I said before, this is the one exemption that does not have a counterpart in Regulation D, a safe harbor in Regulation D, and also not very clear whether or not the states can require registration of 4A5 offerings. A couple of states, including my home state of Connecticut, have adopted regulations for Section 4A5. So you do have to worry about state law registration when you're doing a 4A5 offering. Last but not least is Section 4A6. Regulation crowdfunding allows you to offer up to $5 million over a 12-month period, must be done through an online portal registered with both the SEC and FINRA. WeFunder.com is probably the leading crowdfunding portal in the U.S., but there are a bunch of others as well. Basically, and it must be done under regulation crowdfunding. You don't have a safe harbor here. You must do what regulation crowdfunding tells you to do. To qualify for all the exemptions, you must file Form D in the SEC's Edgar database and sometimes also the NASA electronic filing depository. Always remember that Form D requirement. That's the one thing you have to do if you are relying on any of these exemptions. Is you got to file that Form D with both the SEC's Edgar database and with the NASA depository. Okay, so accredited investors, we've been using that term pretty much, a lot. Basically, it's people who do not need the protection of the federal securities laws, either because they are too rich or too sophisticated. They don't need the protection of a consumer protection law. They're not consumers. These are very sophisticated people. They're defined in SEC Rule 501. Basically, all institutional investors, directors and officers of the issuer, people with $1 million net worth or more, 200,000 annual income individually, 300,000 annual income jointly with spouse, or securities law professionals. So, for example, your broker who has a Series 7 license would be considered an accredited investor. Non-accredited investors is everyone else. And they must either, in order to receive securities, they must either be sophisticated or be represented by someone who is. All offerees must sign an investor questionnaire. It's a very standard form. You can get it anywhere online. And for accredited investor-only exemptions, such as Rule 506 C or 4A5. You may have to review tax returns and other proof of accredited investor status beyond the questionnaire. You may have to look at their tax returns. You can't just take their word for it. There are people who will lie on these forms and say, hey, I'm an accredited investor, when they really don't meet the qualifications. You may have to do some due diligence, especially if you are relying on an exemption that can only be made to accredited investors here. How do you deal with non-accredited investors? So let's say you do an offering and Clem Hopper, some rube comes out of nowhere and he wants to buy shares. Rule 504, the SEC doesn't care, but the states take over here. They basically have rules that limit the number they may require a disclosure statement. NASA does have a uniform disclosure statement. It's Form U7, but a lot of states don't require that. They have their own form. New York is an example where you have to use their form, not the NASA form. Under Rule 506B, up to 35 are allowed, but they must receive an offering memorandum containing the same information as an SEC registration statement. Rule 506C, no non-accredited investors allowed. 4A5, no non-accredited investors allowed. Section 4A6 and regulation crowdfunding. I apologize. Regulation crowdfunding used to be known as Regulation CF. It's now known as regulation crowdfunding. No limit on non-accredited investors, but there are limits on how much these folks can invest in crowdfunded offerings. So someone making only $30,000 a year in income cannot invest $5,000 in your client's crowdfunded offering. They're limited to $1,000 per offering in general. That's a rule that you have to become familiar with. General solicitation and advertising is defined in Rule 502C. Basically, it's any type of public announcement of the securities. Basically, and this is a little something. So let's say, for example, your client gets an offer to appear on Shark Tank, or they get an invitation to speak before a local angel club or network of angel investors. There's a very specific SEC no action letter. I gave you the citation in the notes here that says that that is not considered a general solicitation or advertising, as long as there is some evidence that the people that you are pitching to are all accredited investors. See, on Shark Tank, the reason why Shark Tank can get away with what it does is that the people that are pitching are not pitching to you, the general public. They are pitching to the sharks in the room, each of whom meets the accredited investor qualification. That's how the Shark Tank people get around the rule. Okay, Form D, we've mentioned this several times. It is required for virtually all the federal exemptions except regulation crowdfunding. If you're doing a crowdfunded offering and the offering is registered on a portal that meets the SEC's requirements, you do not have to file a Form D. It's a notice of sales that must be filed within the SEC within 15 days after the first sale of securities. It must also be filed electronically. It must be filed electronically with the SEC using the EDGAR system. If your client is not registered with EDGAR, they must do so before the offering takes place. They have to file Form ID, which is an electronic filing, to actually get what they call a CIK number. That's like a social security number with EDGAR. You use it every time you do a filing with them. It's a little bit of a difficult process, but once you go through that, it's usually pretty easy to file a Form D with EDGAR. And then for offerings under 506B and C, you should file Form D with the NASA depository as well. I know this is kind of redundant. I'm repeating myself a lot, but I just want to reinforce a lot of the basic points here. Regulation crowdfunding, you can offer up to $5 million over a rolling 12-month period. You can use general solicitation and advertising, but it can only be done through a portal which is registered with the SEC and also with FINRA. Virtually 95% of all crowdfunded offerings are on WeFunder.com, StartEngine.com, and Republic.com. These three portals have sort of have almost a monopoly on crowdfunded offerings within the United States. There are limits on how much non-accredited investors can invest in these things. Offering documents must follow strict guidelines, and all communications with investors have to occur through the portal. You can't just send emails to people, answering their questions. Everything's got to go through the portal so that the information is available to all prospective investors. Best suited crowdfunding. I mean, I wrote a whole book on this, but crowdfunding is really best suited for businesses that aren't likely to attract traditional venture capital. So, for example, breweries. Alcohol is a very big industry in crowdfunding. Your favorite craft brewery probably has launched a crowdfunding on one of the big portals. Also, non-scalable businesses with huge social media followings, restaurant, entertainment. So, for example, if you are a fan of an 80s rock band, a famous 80s rock band, and they decide to launch a Broadway musical, a jukebox musical based on their music, crowdfunding would be an excellent way for them to raise money for this, because they've already got millions of social media followers that they can tap into to raise the money that they need for their Broadway show. I actually know somebody who's doing that right now for a rock band from long ago, a baby boom, era rock band, classic rock band. It's a band that you probably have heard of, but they're actually using crowdfunding to raise money for a jukebox musical on Broadway. Okay, so how do you comply with the federal, state, and securities laws? First of all, review the client's offering and try to shoehorn into as many of the federal exemptions as possible. Okay, there are several exemptions. You can tell they do overlap a little bit. So often you can qualify for more than one. You should qualify for more than one. How many accredited investors are there? These are the questions you have to ask the client. How many accredited and non-accredited investors are there? Make sure you register your client with Edgar. Make sure you file your Form ID. Do it before you do the offering. It's a time-consuming process. It takes about a week to get registered with Edgar. Make sure you give yourself enough time and file the Form D with both Edgar and the NASA database. Then prepare a pitch deck or an offering statement for each non-accredited investor if you are relying on Rules 504 or 506B. Those two rules require a disclosure statement to be delivered to all non-accredited. Accredited investors can get anything that they want. Nobody cares, but non-accredited investors have to get a disclosure statement that meets the rules requirement. Then, secondly, obtain a list of all the states where each of the offerees reside. Research the state blue sky law of each state and determine which exemptions are available. If filings are required, file them, and then make sure you file Form D with the NASA. Filing Form D with the NASA depository gets you 95% of the way of complying with most state securities law exemptions, but not all the way. Okay, so that's an overview of the federal and state securities law. The rest of the program, I want to talk about that pitch deck or that offering statement that you're doing for your client. Generally, these are PowerPoint presentations now. They used to be very detailed books. They were like this. They usually came in notebooks with index tabs and stuff. Since the digital revolution, we don't do it that way now. These are PowerPoint presentations, and they have all the limitations that PowerPoint presentations have. Let's define some terms first. What is it? There are teasers, pitch decks, and offering memos. A teaser is an informal summary of the company and the offering terms designed to sort of figure out, to test the waters. Is the market there? Are there people interested in buying this? With the understanding that a more formal memo will be sent to investors later on. The teaser usually contains few hard facts. It may highlight only a few positive details about the company and its proposed offering. So, for example, information on revenues may be available, but they may not want to go into detailed cost information. If sent by a broker or investment bank, the name of the company may be omitted. The investment offered is defined, but no prices are mentioned. This is a very preliminary, think of it as a testing the water document. Is there sufficient interest? Hey, I've got this hot restaurant. I'm going to do a crowdfunding. Would you be interested in investing in this if I did it? It's not an offer. And you always have to include very specific. This is not an offer of securities. You can only make an offer under the SEC rules. This is a pre-offering thing. A pitch deck is an offering document. It is a PowerPoint presentation with an overview of the issuer's business plan and a request for funds, and then an offering memo, which is a formal document containing all of the information required by Regulation D in order to qualify for one or more of the federal and state securities exemptions. It can be a very detailed document. document. It can be a PowerPoint presentation. It doesn't have to be a physical book, although I think it's still better if you use dead trees in a book because it's more formal. It sends a stronger signal to the investor. But make sure that you include all the information that Regulation D requires in an offering memo. Don't leave stuff out. Okay. And what are those contents? Well, that's spelled out in Rule 502B. Basically, non-financial information is required. That's required by Part 2 of SEC's Form 1A. Offerings for offerings up to $20 million, the financial statement required by financial statements need not be audited. For offerings over 20 million. The financial statements must be audited. That's a very important distinction. For Rule 504 offerings, again, the federal, you don't have to really worry about the federal requirements. Basically, in Rule 504, what the SEC did here is they said, you know what, these offerings are too small for us. We don't really want to get tons of information about, small offerings of under $10 million. We're going to let the states regulate this. They deferred to the states is what they did. And so whenever you're doing a 504 offering, it's very easy to comply with the federal rule. All you got to do is file Form D with Edgar and you're done. But it's the state law requirements that are going to keep you busy at night, figuring out exactly what you have to do in each of the states where the offer is required. It's okay to use a pitch deck as long as it contains all of the required information. What I do, a little trick, is that when I'm doing a pitch deck for a client, I put the more detailed disclosures in separate PDF documents and I reference them in the slide deck. So, for example, revenue and cost projections, see attached document, financial disclosures. And then that PDF file gets sent to the investor along with the pitch deck. Whenever you send a pitch deck to an investor that references other documents, make sure the other documents are included in the email to the investors. It's so basic, but people sometimes overlook that. It's okay to do it that way. You can refer to another PDF file that goes into the 10-page disclosures and all that kind of stuff. You don't have to clutter up your slides with detailed disclosures, but they have to be there as part of the solicitation that you make to the investors. Okay. Basically, I've been reviewing business plans my entire career. I probably have seen anywhere between 500,000 and 1 million business plans in my life. These are the 7 things that must be disclosed that Rule 502B requires to be disclosed in either a pitch deck or an offering memo. A description of the client's products and services, a description of the market, the size, the demographics, how big is it, what percentage of the market do you think you're going to get, a description of the client's marketing and promotion plan. What are they going to do to raise money? How are they going to advertise? How are they going to promote? Is it going to be strictly social media? Are they going to have a website? How are they going to reach out to their customers? A description of the competition and the client's competitive strategy. In my experience, 90% of the business plans that I look at or pitch decks that I look at from my clients omit this disclosure, but it is required by Rule 502B and you must do it. You have to talk about your competition and what your strategy is for beating them. Why are you better? Why are you faster? Why are you cheaper? Where's the value proposition here? Especially if your client is going up against large companies, that has to be very compelling disclosure. Our competitors include Apple, Microsoft, and X. But we think we're better than they are. We think we're smarter than Elon Musk. Okay, that has to be a very, very precise disclosure, and you really got to be convincing there, or else people are going to throw these things in their junk folder. You can't do that. A description of the management team, and not just here's Susie Cream Cheese. She's going to be our director of HR. Don't just do resume type stuff. Where do these people add credibility? A venture capitalist that I have done business with for 30 years said, Cliff, when I invest in a company, I don't invest in the concept. I invest in the people. I do read the concept. I do care about it. But then I look at the very second thing I do. After I read the summary, the executive summary that gives the overview of the business, the next thing I do is I look at the management resumes and I ask myself, do these people have the credibility needed to build this business model? Do they know the market? Do they know the technology? Do they understand how people really go out and buy things in the real world? If I can't get comfortable with the management team, I do not look at the rest of the business plan or the pitch deck. I do not look at it. I want to see, do these people have the horses necessary to win this race? And I got to get comfortable with that. So really spend some time. A lot of people blow off the management team. They just throw up some resumes, some executive summary resumes in a slide and move on. Don't do that. That's one of the most important things your investors want to look at. Financial disclosures. For established clients, for companies that have been around a while, you want to have detailed statements. You want to have, income balance sheet, income statements of cash flow, prepared by an independent CPA. For startups that haven't started business yet, what you really want to do are cash flow projections. You want to do, estimates of revenue and cost over a period of usually 6 to 18 months is standard. These are usually little Excel spreadsheets. You have the months of the year at the top, and then you basically do an income statement, a projected income statement for what you think is going to happen in each of those months for the next 6 to 18 months. And it's very popular too to give several different cash flow projections. So I call it a threefer. That's where a client is doing projections based on a worst case scenario, a best case scenario, and an optimal scenario, what we really think is going to happen. And those are different tabs in the Excel spreadsheet. They're three separate spreadsheets. That's a very popular way to organize that information. That way the investor can see, well, okay, the optimum looks okay, but frankly, we're not buying it. There's no way they're going to sell that many units in the first 6 months. Let's look at the worst case scenario because that's probably what's going to happen. That's perfectly okay to do that. Give your investors a range of options that they can look at. Again, because nobody can predict the future. Everybody's, to some extent, any investment in a startup company is a roll of the dice in Vegas. It ultimately is. No matter what, no matter how well organized or how educated your client is, it's ultimately a roll of the dice. And it's important to give we call that stress testing, where you do the three different disclosures, worst case, best case, and optimum. It's called stress testing your cash flow projections. But be realistic here. Whenever I see a pitch deck that says we're going to sell 1 million units in the first month, that's not going to happen. Another thing is too, when you do your cost projections, be sure to be very granular with those. One of the biggest things, and of course, as a lawyer, I see this all the time. One of the biggest mistakes that people make when they do their cost projections, they forget to include legal and accounting fees, which can be very substantial for a startup company. So, there's so much concern about the cost of goods sold that they forget about overhead expenses such as legal, accounting, insurance. They tend to downplay that stuff. Make sure that your client is, if anything, overestimating costs. And then last but not least, risk factor disclosures. Basically, all the things that can go wrong. Now, this is a requirement of, just so you know, it's not just a requirement of state law. It's also a requirement of Rule 502B, that a risk factor, all pitch decks must have a risk factors section disclosing the risks of investing in that company or that security. It is a legal requirement. The second biggest mistake that I see in pitch decks after not disclosing the competition is not having a risk factor section, because the client is nervous about, scaring investors off by pointing out all the things that can go wrong. Okay. Do you need to disclose risk factors of the investment? The answer is absolutely yes. Now, here is this is actually a joke. But a friend of mine put this together years ago, and he allows me to use this. This is the perfect risk factors disclosure. If you have to do a risk factors section in one slide, here it is, right there. It only takes up one of my slides, okay? We are not sure if our products or services work. We don't know if anyone will buy our products or services, how much they are willing to pay, or how we are going to reach them. The competition is extremely fierce, and they are much larger than we are. Our management team doesn't know crap. Okay. We have no clue if we will ever break even or make money doing this. only a brain dead idiot would ever consider buying our securities. This is the perfect risk factors disclosure. Now, of course, I'm only kidding. This is for fun and games. But if you actually look at a real risk factors disclosure section, it kind of looks like this. It says, we believe this is going to happen, but we cannot guarantee or assure you that any of this is going to happen. A good risk factor section is usually between 5 and 10 pages long, and it's always an attachment to the PowerPoint. It's okay to do it that way. 90% of my risk factor disclosures are just a slide that says, please see attached risk factors document. My clients like that. Why? Because we've complied with the law, we've disclosed the risks, but we haven't stuck it in the investor's face. Most investors, especially sophisticated ones, will look at this and say, you know what, yeah, it's the usual garbage. It's all the stuff the lawyers throw in. We're not even going to look at that. And that's okay. The client is happy with that result. You know, we've offered it to them. But we've also done it in a way they don't have to look at it if they don't want to. That's the Goldilocks solution for doing a risk factors disclosure. Okay, so again, this is a 1 hour presentation. I could easily do a 3 hour or a 5 hour presentation on what I just covered. But again, it's just an overview to help the non-securities law practitioner figure out what to do when their client starts offering securities to people that they don't know. And here at Cliff & Co.'s rules, number one, keep the number of offerees as low as possible. The more people you offer to, the more likely, number one, that you're going to have non-accredited investors in there who need to be disclosed because they're not sophisticated players. Also, too, you will probably blow the de minimis exemptions in some states. Some states, like I said, have very small numbers of investors. And if you go beyond that, you have to do stuff. So if you keep the number of offerees as low as possible, and especially if you only have like 1 or 2 offerees in each state, that is ideal. If you have 30 investors and they're all in one state, it's much more likely that you're going to have state law compliance that you have to deal with. Avoid non-accredited investors unless they are absolutely necessary. The one categorical statement I can make about all the federal and state exemptions is that if you are offering only to accredited investors and you've taken the time to make sure that they are accredited investors, you will not have too much to worry about under the federal or state securities laws. There will be at least 1 and possibly more exemptions that will be available. And these are the people that the SEC and the state regulators do not care about because they know what they're doing. So try to limit your offerings to accredited investors, as much as you possibly can. Shoehorn into as many exemptions as possible. Now, if you've really been paying attention, I can hear some of you saying, well, wait a minute, I heard about that 504 exemption where you have to do the state law. I'm not going to rely on that. I'm just going to rely on those 506 exemptions because I don't have to worry. They've been preempted by the federal government. I don't have to worry about the state laws. I'll just file that Form D with NASA and off I go. That may be okay to do, but I would also say there may be a circumstance in which the 506 is not available, and if that's the case, you want to have the 504 to fall back on. So I tell my clients, look at the state law rules, see how difficult they are to comply with, and try to comply with at least some of them. You may not be able to do it in all the states, but if you've got 10 investors in one state, that might be a good one. If all they require is a 2-page offering statement, do it. Comply with the state law. Try to have as many irons many arrows in your quiver as possible. Don't just rely on one exemption because they are all, as Mark Twain once said, if you put all your eggs in one basket, that's fine, but just wash that basket. Okay. Know the de minimis exemptions in each state where the offerees reside. There is no 50-state survey that I'm aware of, but with AI, you might be able to do it to get a 50-state survey of the de minimis exemptions of all the 50 states. I'm surprised that nobody has actually done that and put that up on the web. At least I can't find it. It might exist, but I just may be missing it. But with a good AI, you might be able to say, find the de minimis offering exemptions in all 50 states. You might be able to get a document that's fairly accurate, and you may be able to use. Here's one good way to use AI if you're not using it already. If you are relying on Rule 504, 504 ignore the reference to 506. If you are relying on Rule 504, you have to know the state filing requirements. Obviously, all the states have rules regarding 504 offerings. File Form D everywhere with the SEC, EDGAR, and with the NASA. Make the client's pitch deck as detailed as possible. Make sure you include a risk factors disclosure, even if it's just a separate document that you reference in the pitch deck. And then last but not least, know your limitations. And this is the slide that I want to close on. Are you covered by your malpractice policy? When you are applying for your malpractice policy, if it's your initial application, if you're just going off on your own, or if you're renewing your existing coverage, make sure to include securities law when filling out the areas of practice section of the application form. The chart that lists all the different specialties and said how much of your percentage of your practice is devoted to each of these areas of practice. Don't just put 2% in each of the boxes, but make sure you include securities laws, because a lot of insurers will not cover you for securities law unless you specifically say that you are practicing in that area. You may have to fill out a separate securities law rider in order to obtain coverage. You will almost certainly get a higher premium due to the higher likelihood of lawsuit. Generally speaking, when investors are unhappy, they sue. And they don't just sue the company and the company founders. They sue the lawyers, they sue the accountants. Any name that appears on the pitch deck will get sued. Okay, that is almost a certainty. Investors are not exactly known to be, cuddly, touchy-feely type people. If they're not happy, there'll be a strong temptation to sue, and you are in the line of fire. So make sure, get prepared, prepare yourself for some higher premiums. Make sure that it is worth the effort. Make sure that you are getting enough business in this area to justify the higher premiums. And last but not least, to be sure to review the exclusions section of your policy carefully and make sure. There are some insurers that are very sneaky. They don't say that you have to specifically state securities law. They say that you're covered for everything, but deep in the fine print of the exclusions section, they say in anything regarding a claim under the Securities Acts of 1933 or 1934, they bury it in the fine print of the policy. You should always read the exclusions section of your policy anyway to see what is not being covered, but look out specifically for securities law claims if you plan to practice in this area or represent startup companies. So that is it. We are exactly at 1 hour. I think I've covered all my material. Nina, thank you as always for having me. It's always a pleasure. And let's see, do we have any messages? We do have one message here, which I'm going to read out loud, and that is, how would you have remedied the client you mentioned who was conducting unregistered public offerings? Do you report it to the SEC, or do you just do a new 506 offering and include the past investors and give them a chance to sell back the stock they purchased? So this is a very good question. What do you do when you see that your client has done an unregistered public offering and they've made no attempt to comply with the federal securities laws? Well, as I said in my example, I offered them a fee for helping them with this, and they just didn't return any of my phone calls or whatever. But I'll give you one possible answer. It was very clear to me, and I got to be very careful here because I can't disclose information that is too specific. But the business that the company was engaged in was a public benefit type of business, like a social enterprise, where they're not just doing things for the public, but they also have a social mission. One thought that I did have was that they could convert the company into a nonprofit organization under state law, and then treat the investments as donations, which would be tax deductible. Not only would that get them off the hook for a securities law violation, but it would give the investors a tax return, a tax deduction. That was one thought that I had, but it's very difficult to unwind that. One of the penalties, I mean, the one way that you can unwind a bad securities offering is to simply give all the money back to the investors, maybe with a little bit of interest. That way you still violated the law, but it's no harm, no foul. There's no damages. But unfortunately, most of my clients, they spend the money as soon as they get it. So the money's just not there. to refund to the investors. It's very difficult to unwind a bad securities offering. That's why we focus on prevention. What are the best practices for verifying an investor's accredited status? Well, the first thing you do, always send an investor an accredited investor questionnaire. It's a very standard document. It asks all the questions under Rule 501. They check the boxes. And in most cases, you can rely on that. But if you have reason to question someone, it's a good idea to delve beyond that and request a copy of the client's most recent tax returns. I mean, if they're lying to the IRS, they have much bigger problems than lying to you. So, that's one thing you can do. Obviously, you're going to have to make sure that if the investor's got a brain in his head, he's going to ask you to sign a non-disclosure agreement, which you should have a standard form for that. But don't question, because people change. During the pandemic, a lot of people that easily qualified as accredited investors woke up one morning to discover that they were no longer accredited investors because their portfolios got wiped out. During the recent tariff scare in Wall Street, a lot of my clients were concerned that they no longer qualified as investors because the value of their portfolio dropped so much. Things can change in this area. Even they may not be aware in good faith that they're no longer accredited investors. My advice to any client, especially those that are relying on the accredited investor only exemptions, where all the investors have to be accredited investors, do some diligence. Don't just rely on the questionnaires. Kick the tires a little bit, because if you make one mistake, you're screwed. What are the common pitfalls associated with Form D filings? Well, not doing them. The form is a very easy form to fill out, actually. It only takes about 5 minutes. They don't ask for a lot of personal information about the investors. They just want to see overall numbers and stuff like that. Not doing it is the biggest pitfall. The other pitfall is not realizing that, especially for 504 offerings, you may have to do, for 506 offerings, that you may have to file also with the NASA database at the state level. That's the one requirement that survived the federal prevention statute, Section 18 of the 33 Act. They did allow states to require a Form D filing, quite frankly, because they wanted the states to get the fees. That's what it was all about. When you file a Form D with the state, you pay a fee, and the states were nervous about losing all this revenue to the federal presumption. So that's why they let that requirement in, so that the states would still get some money in filing fees. It was purely political, no legal, logical reason for it at all. It was just an attempt to keep the state securities offices alive. At what point in the capital raising process should a general involve a securities law specialist, and what factors should influence this decision? I'll make this easy. Whenever you are not comfortable with what the client is doing and whether or not you're covered under your malpractice policy, that's when you should bring in a securities law specialist, someone that knows what they're doing. Whenever you see, if you get nothing else out of this last hour, okay, whenever you see your client offering stock to people that they don't know personally, that they do not have a pre-existing relationship with, that's when you should trigger, securities law. This applies here. Do I feel comfortable doing this, or should I bring in somebody else? That's the best advice I can give you in a 1-hour presentation. And then lastly, is there a bright line rule on the extent of due diligence required to determine if someone is an accredited investor? Can you rely upon an affidavit? Well, I already said that it's in most cases, it's okay to rely upon the affidavit, but unless you have reason to question that they didn't know what they were doing. So somebody, for example, who's working as a garage mechanic, does not speak English as a first language, who just checks the boxes, but he checks them all right. I mean, that's a silly example, but if it's quite clear that this is not the sort of person that has over $1 million net worth, you may want to ask them for some backup information for your files to make absolutely sure. Use common sense here. But again, if you're relying upon one of the exemptions that require that every single investor be an accredited investor. So 506C, for example, 4A5 is the other one. Make sure, if you're really relying on these exemptions, the more you are relying on that one exemption, the more diligence you have to do to make sure you're not blowing it. Nina, I think I'm all talked out. I think that's it.
Awesome. Thank you so much, Cliff, for answering all of our audience questions and sharing your insights through your presentation as a whole. And thank you all so much for submitting your questions. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier today, don't forget to take advantage of the powerful free legal resource available to you as a Justia Connect member, our Justia Daily Opinion Summaries. You can get next day alerts with concise summaries on the latest court opinions for the selected practice areas and jurisdictions that matter most to you, delivered right to your inbox. You can sign up by going to newsletters.justia.com to stay informed and stay ahead, and have a wonderful rest of your day. Thank you all so much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.